he can have two on, only one target. And on the third row. He's in the right spot. They're getting a line. They're getting it's just like when we were here.
Yeah, no, he's.
What's it on? Okay, one each shoot.
How are you? We're here.
Oh, okay. So he thinks it was that.
He's standing there chilling.
Yes, ma'am. On the table? No, they could be. So the problem is because it's going to be done tele, they can't hear you from here. I can turn it back on.
I'll turn it off.
And this is county zero. Oh, they.
I don't have any.
CRD. But it's not service, it's county. It's county. This is county. Just making sure I call it right. No, no, we're not. We've been there. We're just first. We've been there. Lex, we got anything else? Judge Mahan did the rest of the county.
It is. It's probably, it's 255-2447. It was probably blinking and nobody picked it up. Go ahead, try it again. I'm standing here right now. You want me to pick it up? And do what? All right, whenever you're ready, go ahead. Sure.
All rise. Circuit Court CRD NN4 Duval County in the state of Florida is now in session. The Honorable Judge Russell Healy is presiding. Make sure your cell phones are cut to an off position and there's no speaking. Please be seated.
Good afternoon, everybody. Good afternoon. First off, I appreciate y'all being here. Sorry about the delay, but originally what we had set for hearing today was Mr. Strolla's. Well, actually, I need to call him. He's going to appear by phone.
I'm here, Your Honor.
Oh, you are?
I can barely hear you, but I can hear you.
Okay, well, let's see if we can get our IT people to help us with that. And Mr. Dunn is here.
It's
Put
on
the
me directly.
microphone down there and turn the volume up on the.
That'll help with us hearing him, Your Honor, but for him to hear you, you're going to just have to speak up because it's so far away.
I'm not a microphone kind of a person generally. Usually you can say my voice is loud enough, but there we go. Whoa. All right. Does that help, Mr. Strolla?
Yes, Your Honor.
Okay. So what I was saying was, originally what we had set for today was Mr. Strola's motion for continuance, but because of some other reasons, I amended the notice of hearing and felt that I needed to push this back a little bit to make sure everybody had as much time as they could to be prepared. So our hearing today will be about Mr. Strola's and Mr. Dunn's motion for continuance of the trial. There is also a motion by Morris Publishing and some other media outlets to set aside some prior orders of the court, direct the clerk to unseal some documents and unredact some other documents, things of that nature. There is another motion along the same lines from Post Newsweek, basically dealing with the same type of issues. The state has responded to that. I believe the defense has responded to that. And then there's also the defendant's motion to determine confidentiality of court records and for protective order sealing certain court records. So in essence, we have two separate issues, if you want to call it that. One is the motion for continuance, and then all the other motions really pertain to the same subject matter from what I can gather. So my intention was to first start with Mr. Strola's motion for continuance. And so, Mr. Strola, you can go right ahead.
Thank you, Judge. Judge, basically what I filed is pretty much on the four corners of the document. The crux of it was, because we're right into the heart of trial preparation, the trial is literally a matter of, days away. There's been some filings, both by the interveners, one being a 16-page motion, one being a 9-page motion, plus there was an emergency motion filed by Mr. Gable, one of the interveners with the DCA. And based on responses and time and research, it's taken away such valuable time of me preparing for Mr. Dunn's murder trial. And it's such a severe case with a massive amount of discovery. It was interfering in proper preparation for him to have a fair and valid defense, pretty much to put it bluntly, Judge, is I've had to dedicate so much time with the media issues and the intervening issues that, of course, didn't start until, I believe, October of 2013. And again, if the trial wasn't set for 2-3 months away, that would be one thing. But here we are literally days away from picking a jury, and I've got to deal with multiple motions from multiple interveners, again, taking tremendous amounts of time away from me representing Mr. Dunn effectively and properly. And I know Mr. Dunn probably doesn't like the fact that I filed a motion to continue. He is very anxious to clear his name and go to trial. I can assure that to the court. I've got to protect Mr. Dunn's rights, and I've got to protect his future with this jury trial. And with everything that's going on, what I would call as an outside distraction, other than the heart of this case and the matter, it's tearing away a valuable time to defend Mr. Dunn properly and effectively. And I felt, in the interest of my client and justice, I had to file this motion to continue. I was not doing it just to delay the trial, Judge. I think we've been set for trial for a couple of months now. And again, if the trial wasn't set for another few weeks away, I don't think I'd file this motion. But when we're literally days away from picking a jury, and I'm still dealing with days and days and hours of handling media motions, it's absolutely interfering with his right to have a fair trial and an effective defense, Judge.
Ms. Corey.
Your Honor, we understand Mr. Strola's position. We, too, think that it is basically unfair to both sides, that we are trying to deal with the substantive issues of a very important criminal trial, and we're having to stop everything we're doing and deal with not just one motion, but multiple motions, multiple responses, and the like. That is a plague that our colleagues in virtually every other state in the union don't face, nor do federal prosecutors or federal defense attorneys have to stop their substantive work to deal with motions by interveners. So I do understand that. However, this court has had us on a very clear and concise track as far as time goes, with regard to deposition schedule, with regard to motion schedule, with regard to every aspect, every procedural aspect of the trial. And we believe that if the court can resolve these intervener motions today, or at least by Friday, then family, and the state, of course, has a right to a fair trial too. We're ready to go and do it. We think it's in Mr. Dunn's interest as well as the state of Florida's interest to go ahead and get this trial done.
Mr. Dunn, I suppose for the record, I probably, the motion was not sworn to or adopted by you personally, so I want to, for the record, know if you're joining in the motion or if you recognize Mr. Stroll as filing it but object to it, or are you acquiescing to it?
I would acquiesce, Your Honor.
You would?
Yes, sir. I rely on his advice.
Okay. All right, well, I'll deal with that shortly, I hope.
That's correct.
Is that right? Okay. Generally speaking, basically, raising the same or very similar issues, there are some specific references to certain docket entries that are part of the clerk's file, and there are a couple of differences between the two, but in essence, the issue, I think, is pretty much the same. And so, Mr. Gable, Mr. Burke, whoever wants to go first. Yes, sir. Good afternoon.
Motion. I'm here on behalf of the Florida Times Union and First Coast News. Our motion had several aspects to it. One was directed toward previous orders entered by your predecessor and by you. The one particularly by you was in August of 2013. The original order, as noted in the defendant's motion or response, was to be a temporary order, 120 days. As it now appears that the media received notice of that motion when it was filed, that order was then continued by Your Honor on August 1 without a hearing, without notice to the media, without any evidence of that would cause imminent harm to the administration of justice, which is the requirement of the Lewis case. And so the problem is that with these jailhouse calls, the state attorney, and I suppose the defendant as well, are relying on that order to say we have to redact the names of witnesses.
Okay.
And so that's the hitch in producing these records. They said in their papers that they have reviewed all the calls. They've made summaries. We're not asking for the summaries. And so without their having to redact the witnesses' names, they should know if there's any confidential information that needs to be redacted very quickly in there. So I think the appellate court has made it pretty clear, although perhaps it's implied, but in the January 17 order, by the way, they do mention about the ongoing violation of the public's constitutional right of access to public records. I think we had that discussion before. A recognition that, I mean, it has to be a balance, but that there is a constitutional right of access to public records. But they say, quote, "We hereby order the disclosure of all criminal discovery produced in this case, including but not limited to the defendant's recorded conversations," and then made it subject to Your Honor holding an evidentiary hearing if there was a motion filed. And there has been a motion now filed.
Now there has.
Yes.
But that order came out, I believe, well, there was one on December 18 that made some references,
Right.
not as direct as that one.
Right.
It did not address the April or the August orders, which has been represented that perhaps it did. I'm not saying by you, but it did not.
I said implied was what I said.
Right.
Yeah.
And that order that you reference, and I've forgotten the date of that order.
It was Friday, January
Right.
17th.
So, and here we are on Tuesday. The difficult thing is, I think what's been portrayed to some extent is that the December 18 order from the district court said something as direct as that when it did not. And once that order was entered, it vacated my order where I tried to, in essence, put a buffer in, which we've talked about, to allow sufficient time for someone to review these calls. Because for the record, it's been represented to me that there are 180 hours of phone calls that have been made, which would obviously take quite some time to go through. So that was the intent, was to put a buffer in there to allow particularly the defense and the state to go through it to whatever detail they needed. But once that December 18 order came down, there was nothing else for the court to do because nobody filed a motion. And it's been discussed that the court refused to do something, and that was not something that I did. I did not refuse to do anything. There was no motion before the court to do anything about. And seemingly, my order, where I tried to put this buffer in there, it was vacated and set aside, so you're back to kind of square one. Now, what happened from there, I now see what you're saying is that, and we'll hear from Ms. Corey and maybe Mr. Strolla, that perhaps part of the reason they weren't disclosed was the April and August order about the civilian witnesses' names and addresses being determined to be confidential. So I see what you're saying.
Yeah, that's my understanding of the reason they've not been produced. And it's not really the April order. That one would have expired of its own terms. It's the August order that continued it through trial. And there is no exemption in the public records law for names of witnesses, addresses of witnesses. And the argument is being made, at least I heard it before, I don't know if it'll be made today, that by releasing the names of the witnesses, that may cause them to be intimidated or somehow. But the depositions have all been taken, as I understand. There's no evidence that the media would intimidate any witnesses. And in any event, they say there are 100 witnesses. It seems like if there's one witness they're worried about, they should say, not just say all 100 witnesses. So this is an interlocutory order. The court certainly has the power to change that order, particularly when it has been brought to your attention that the procedure was perhaps not the right way to do it. And so that's the first part of our motion to set aside the August 1 order. There have also been a number of documents that have been sealed, perhaps because of that order. That may well be it, because it has some names of witnesses in it.
I think that's exactly what it is.
Yeah. So we've asked that those be unsealed and unredacted if it relates to witnesses. And that's essentially what our motion is.
And again, for the record, I think you alluded to this in some of your filings. We did have, I say we, the state attorney, yourself, Mr. Burke, Mr. Strolla, and I had a conversation at my behest via the phone, I guess it was last week,
Right.
where we discussed some of these particular documents that you referenced, that are referenced in your pleadings,
Right.
Clerk's entries, if you will. And as I looked at those and went through them after I'd had time to review these motions, that's exactly what that seemed to me, that either there are redactions in there of the names of witnesses, or perhaps a document was completely sealed, and from what I can see, seemingly because witnesses' names were contained within the document itself. Mm-hmm. And so I think what was happening was probably the clerk was abiding by the April and the August order and handling it that way. So
That's my
I
understanding.
hear what you're saying. I think
that's my
what
understanding.
happened.
So
Okay.
once that August order is vacated, if Your Honor sees it that way, then
That should clear that up.
That should clear that up.
Right.
And having made summaries of all the calls, if there was a confession of some kind in one of the documents, then that can be redacted easily. And we pay whatever the cost is for for that to be done. We pay for the cost of the tapes or whatever, which is expected, but not $6,000 to take out the names of all witnesses.
Well, in a minute, you mentioned summaries. A minute ago, you
We're
said,
not asking for summaries.
Okay, you're looking for the tapes
Right.
themselves.
No, that would be their work product.
Right, okay.
Yeah.
And again, for the record, this issue has been quietly ongoing. Well, now it's not so quietly, I guess, but it's been ongoing for quite some time because the state listed these calls in their discovery documents several months ago, and the media requested copies of those pursuant to public records laws. And I've been made aware of the fact that there were correspondence back and forth between the state and the media regarding procedure on how to go about it and funds that would be required and such as that. And it seemed to me that, obviously, from what I gather, no monies have changed hands to pay for these things. And it seems like there's a dispute over maybe how much it should be or what's reasonable or to what extent the state has to go through these records. And that's been a little bit lost, I think, not only with the public but in the appellate court, that there was just a log jam there, seemingly, between the media and the state as to how and what the state was required to do pursuant to the Florida statutes as it relates to the public records, and have somebody review these things. So,
Well, Your Honor, one exemption in the public records law is an order of the court, and that apparently is what they're relying on, is the order protecting the names and addresses of the witnesses. And since they've already been through all the tapes and that requirement would be removed, then they should just turn over the documents.
I tend to agree with you. I got the impression, and we'll hear from Ms. Corey about it, I got the impression that it was more than that, but I guess we'll hear that in a moment. Thank you, Mr. Gable.
Thank you, sir.
Before I go to Ms. Corey, Mr. Burke, do you want to add anything to that?
Yes, Your Honor. Thank you. Good afternoon, Judge Healy.
Good afternoon.
May it please the court?
Yes, sir.
A couple of points. We are asking for the summaries, or at least an in-camera examination of the state summaries, because without knowing what's contained in the summaries, we can't make a determination of whether it's work product or simply factual descriptions of the tapes. Work product protection, of course, wouldn't apply to simply factual descriptions, is our position. And the review of the tapes, Your Honor, the state has now, as I understand it from prior hearings, gone through the tapes for evidentiary purposes to determine which tapes might be valuable to the state's case as a matter of evidence. And in doing so, they would have made the same analysis as the public records review, which would be for instance, determining whether there are any adverse admissions or confessions contained within the tapes. Certainly, I would expect the state would, if they found a confession within the tape or even just a mere adverse admission, they would want to introduce that to the jury. So in that sense, we believe the state has already gone through the exercise, at least for that purpose, without regard to the civilian name, reviewing the tapes for the civilian names. So because of that, in the summaries, I might tell the court, might tell us what is contained in those tapes, at least in the way of a possible confession or substantive confession, if one exists. That should, if nothing else, reduce the cost to the media of obtaining the recordings.
Okay.
And if I might, Judge, we join in with Mr. Gable's clients on the redactions by the clerk's office.
Correct.
Yeah. I know they're being very diligent in trying to comply with the law. We just think they've gone too far.
Okay.
Your Honor did ask at a prior meeting for an example of what the public, I believe, sees on the docket versus what I
Right.
might see. And I do have copies of.
Okay, that'd be great. And again, for the record, that was something that we discussed in the phone call we had last week. That was impromptu, and there was not a court reporter that could take it all down. But
Okay.
one of the concerns that I had is the court gets to see, I guess, everything on this clerk's screen. As I understand it, then some things are restricted and perhaps only lawyers or lawyers that are parties to the particular case could see it. And when I say it, they can go online at home and remotely see these things. And then the general public has another level of entry, if you will, to the system. And so sometimes when these things are being discussed, I'm not clear on what you're seeing because it's different than what I'm seeing. I get to see the unredacted. And so I just wanted to kind of see how it shows up on the screen for you so I'd have a sense of how to rectify it.
Your Honor, if I could explain that, I've handed you two documents. One is legal size, the long one, and one is just 8.5 by 11. The legal-sized document is, they're pictures, screenshots of what I was able to look at this morning. And they show on the right-hand side of each page, if there's an image associated with a docket entry, there's an S, and I'm not sure exactly what the S stands for, or there might be an R, which indicates some level of redaction or sealing. Then on the short form, do not appear to be, and I believe this to be correct from my client, there do not appear to be images shown on the short form.
I see.
And I think the point was raised when this all was discussed, that in the text of the docket, there's no way to know if a document has been sealed entirely or redacted in part, or by whom or what particular exemption.
The
might
general
apply.
public wouldn't know that.
That's correct, Your Honor.
So this letter size is kind of the general public's view, and this legal size would be the attorney's view.
I believe that's correct. The legal size is definitely the attorney's view because I pulled it up, and I believe this shorter one is what the public would see.
I see. All right. Any objection to making these a part of the hearing in the record?
No, sir.
None from the defendant, Judge.
I'm sorry, Mr. Strolla?
No objection from the defendant, Judge.
All right, then the legal size would be, we'll call it
The attorney view, perhaps?
intervener, which, I mean,
Post Newsweek?
Post-Newsweek, we'll call it intervener Post-Newsweek's Exhibit 1, and the legal size will be intervener Post-Newsweek's Exhibit 2.
Thank you, Judge.
I'll give those to the clerk.
Just for Mr. Strolla's information, I have handed copies of these two documents to Mr. Dunn.
Thank you.
All right.
Thank you, Judge.
Mr. Strolla, would you want to go next?
Sure, Your Honor. Judge,
I mean, you
did
can not only respond to their motions, but you can kind of go ahead if you want, dovetail in your motion, which is really about the same subject
Yes,
matter.
Your Honor. I did file a response, and if you refer to the legal argument section, Judge, I think what keeps being lost here, and I understand that Mr. Diebel and Mr. Burke have a duty to their clients, but what their clients don't have is the right to supersede my client's constitutional right, where we are trying to prevent a serious and imminent threat to a fair, impartial, and orderly administration of justice in this trial, which there's Supreme Court of the United States case law that says that in a criminal defendant's case, we have to secure that right to a fair trial. The defendant is entitled to receive a fair trial, including the state attorneys, and is entitled to their fair trial for their alleged victims and witnesses, and that cannot be superseded. And I believe it's the McCrary case, which is 520 Southern 2nd, and I have it at 34, Judge, which is from the United States Supreme Court, and it indicates, excuse me, there is no conflict between the statute and the constitutional authority of the judicial branch to take such measures as are necessary to obtain orderly proceedings and a fair trial. And here, the only thing I keep hearing from the media, Your Honor, is we have a right to look at it. We have a right for the public to know what it says and know what it does, regardless of how that may affect the outcome. In any case, but to have 15, 20 cameras. And just to add to the fact, Judge, I filed my motion for continuance on January 17th at 11:43 a.m. The only parties given notice and access to that motion were the interveners counsel, the state attorney's office, and myself. And within 15 minutes at 11:57 a.m., news4jax.com by Christopher Yazbez, Y-A-Z-B-E-C, not only had a full published printed article, but actually had a completely unredacted copy of the motion attached to it. So again, they're talking about how the state's already reviewed some of these phone calls. In fact, I haven't reviewed all the phone calls. We're talking about hundreds of hours where not only do I have to sit and listen to what he says, but I've got to take critical notes. And in fact, Judge, to be candid with the court, I'm in the process of filing motions in limine for this Friday to actually try to preclude and exclude some of the comments the state may or may not want to use, as one, they're not relevant, and two, they're 403 overly prejudicial, even if Your Honor found them relevant. And my concern is, if the media thinks they're entitled to this complete audio listings, which I don't think the DCA, or I submit to the court, the DCA did not say the April and August orders are invalid. And in fact, I asked them to clarify their order, Judge, in emergency response, and they declined to touch on that, to clarify the April and August 2013 orders. One, the petitioners are out of time to argue it, but for them to say they didn't get notice, not only does Mr. Franza submit proof that they did, but their own clients are sitting in the courtroom recording everything that Your Honor said in August of 2013, but then they come in October and say, well, Judge, we had no idea. We had no idea you were going to do this, even though they had 30 days to appeal it or do a motion to vacate, and they did not. So I don't believe they've timely filed anything to ask the court to vacate it. I submit to the court the DCA did not vacate those orders. And even if, that being said, my pending motion for protective order, Judge, I think the court can take judicial notice of everything that's been done and posted in this case by outside parties, not the state attorney's office, not the defense, that is going to prohibit Mr. Dunn getting a fair and impartial trial in Duval County within the next 14 days. My point to the court is, if something gets out that should never be even relevant to court, whether the media thinks the public should know about it or not, if that interferes with an impartial jury, then the U.S. Supreme Court kicks in, and they have no right to dispose that or give that out or expose it to the public. And that's where the defendant has a fair trial supersedes anything the petitioners have argued or cited as case law or statute. They're just saying we're allowed to have it, but they're not saying it's in the best interest for the media to put it out there unfettered. And I think that's the point that's been lost in all this, is my client's right to a fair and impartial jury trial in Duval County. And if this gets out to the media and they get to spread it like wildfire, where even I haven't been able to review 100+ hours of it, that's going to inhibit it or prohibit it. And then now I've got to file motions, Your Honor, again, which interfere with his defense for a change of venue. And that's what we've been trying to avoid, Your Honor.
Thank you, Mr. Strolla. Ms. Corey?
Yes, Your Honor. If I may, I have to point out the irony of the media lawyers who instruct their clients on a daily basis to edit their work product, to make sure they don't just take everything down for a particular story and air it all or print it all, because they have rights and responsibilities and legal issues if they just put things out there that aren't supposed to be out there. But the irony of that, that's what they do every single day and spend an inordinate amount of time making sure they only put out a product that has been edited. They're now coming into this court and complaining that the state of Florida, who has a huge responsibility to the administration of justice. As you know, the Supreme Court has called us ministers of justice. And that's the second irony. We are bending over backwards to protect Michael Dunn's right to a fair trial, to protect this case, to allow it to be tried in the venue, which is prescribed by, which is, this normal venue for our circuit, where we need to be, where our victim's family has a right to be. To have this case tried in Jacksonville, Duval County, Florida, without the interference of jurors seeing things that will never pass the filter that we call the rule of evidence. The irony of that they're demanding of us an unfiltered product for them to use as they wish, it's stunning to me. Because the law does allow us to edit this. The public records law is not, as Mr. Gable has represented now for the fourth time in this courtroom, suggesting to this court that we only offered to redact hundreds and hundreds of hours of audio tape statements of the defendant, Judge. Statements that have to be reviewed to make sure there are no admissions or confessions. It has nothing to do with the names of the witnesses. Quite frankly, if there were not a protective order in this case, if there were not media scrutiny on this case, but the case was as complex as it is, and we had all these media calls, Mr. Franza would have sent the same email to the same reporter quoting the same price. Because we have an obligation under 119 to redact statements or admissions. You would think that someone, at least neutral, would appreciate the fact that the state attorney is looking out for protecting those types of statements so that there is not anything inflammatory in the public before we try to pick a fair and impartial jury. But that's our job, Judge. We're required to do that by law. We would be redacting these records, whether you had entered an order or not. We would be charging the media the same fair price based on that. And the fact that Mr. Franza didn't specifically mention that as an aspect of redaction doesn't change the public records law. So if you vacate your order, if you say we no longer need to protect the identity of the witnesses, we are still going to quote them the same price we quoted in the prior email, saying we've got to go through every single phone call to make sure we comply with our obligations under Florida's public record law. So we'd be in the same position, whether this case was high profile or whether there was no protective order about the witnesses' names, we would still be doing the same thing, Judge. And as far as summaries go, those are our work product. They were done under my direction with specific instructions to my paralegal on what I wanted in the summaries. I have that right under Florida law. They are not subject to the public records, and we do not intend to turn those over. Judge, we don't believe that those are any business of the media for them to look at what we have pulled out and determined as great importance. So we will not turn those over, Judge. And the second thing is, again, for the clarity in this case, things have been stated in motions by the interveners that simply are not true. And I would like to somehow, if you would allow Mr. Franza to just clarify some things about the public records, because as you said earlier, it seems that we're battling with the media. We're not battling with the media, Judge. We believe they have a right to publish this information, but it's the timing of when they want to publish it that we have an issue with. And it's also the fact that they expect, and have said at least on 4 occasions now, we're not supposed to be redacting anything. I couldn't disagree with Mr. Gable any more strongly than I am right now, because we do have an affirmative obligation to redact. So would you allow Mr. Franza to just clear up a little bit about the public records procedure, because we believe that there are things in the motions that have been filed before this court and before the First District Court where we couldn't be there to say, no, that's wrong, and where we saw an order entered before we got to file the response. But I think now we file a response and then they entered another order. Is that what I was... Do I understand they entered a second order?
Well, you're right. Interestingly, and this was something I was going to point out, sometimes, and this gets lost a little bit, one, the court obviously is very, very limited in the things the court can say about an ongoing case. Lawyers frame their arguments for their clients as they should. That's their job. But in some instances, particularly some types of appeals, an argument can be made to the District Court of Appeal, for instance, and it's only from one side. The other side doesn't really get to respond, which has happened in this case. So that's, I guess, what you're alluding to. And that happens. That's just the way it works sometimes. So, yes, the only order that's been entered most recently, quite frankly, was there has been an order from the district court based on your, maybe not so much yours, might have been Mr. Strolla's, your motion to clarify, I think, and Mr. Strolla also filed a motion to, I've forgotten exactly what he called it, raising
a motion to modify and then a motion to clarify.
Okay, motion to modify, motion to clarify, raising the issue that I had set this matter for hearing on Friday, even though the District Court of Appeals said I had to have an order out by Wednesday at 4 o'clock. Thus, the reason for this being called so quickly, thus the reason that I amended my notice of hearing to include these motions, because it just has to be done. Well, and I was waiting a little bit this morning to see if the DCA was going to respond, and then when they didn't, that's when I amended my notice of hearing to include everything for today, and then ironically, shortly after that, I did get an order from the DCA. The DCA has extended to some degree, not necessarily the hearing. They've said that I can take until Friday at 4 o'clock to enter a written order. I had until tomorrow. Now I've got until Friday to get a written order in. I could have, I suppose, pushed this back to Friday. I didn't think that was prudent. I want to save Mr. Strolla a trip up here, which we'll talk about later if necessary, so he can concentrate more on the trial itself rather than these issues. And, oh, by the way, I didn't really think having the hearing on Friday and then trying and not knowing exactly how long it would take, wasn't so sure that I could get an order out, a written order out by 4 o'clock. I'm just, I shouldn't say it, we're on TV. I like to say I'm good, but I'm not that good. But I do have people helping me, and they're that good. But I don't like to put that kind of pressure on folks. So that's the only thing that's happened, is the order could be entered as late as 4 o'clock on Friday, but we'll see about that. So, Mr. Franza, I'll give you a couple of moments to clarify what you'd like to as far as the public records and the public records law are concerned.
Thank you, Your Honor. Please support. The basic procedure for public records requests, and I believe Your Honor has seen the exhibits that the state has provided in response to the intervener's motions. There's a very back and forth about how a public records request is done. It can be done over the phone, via facsimile, email, via letter, however method of communication the requester would like to use. We put in a request, we acknowledge the request, we put it in line, and then we get to it. And that's basically what happened here. Simply, with the Exhibit J is an email that was sent to the Florida Times Union regarding the jail calls. And I believe those are the only thing, and thank you, Counsel, for minimizing and limiting what the issue, the public records at issue are, would be just the jail calls, as the state has provided all the other records pursuant to requests. The timing, 185.8 hours. Now, again, that's as of, the date is October 21st, 2013. So there, I believe there are more jail calls at this time that the state has reviewed, but maybe I didn't have copies of them, or maybe they weren't turned over. But as far as reviewing, it's only 185.8 hours that are subject to this. And if you multiply that times 1.5, now we have to listen real time, and we have to listen for bank account numbers, we have to listen for social security numbers, we have to listen to substances of confession. The bank account number is exempted pursuant to Chapter 119.071, subsection 5, subsection B. Social security numbers are exempt pursuant to subsection 119.071, subsection 5, subsection A. Substance of confession, exempt pursuant to 119.071, subsection 2, subsection E. Those are just 3. There are hundreds of exemptions in the public records law that may also, you may come upon something else that may apply. And we have to know this information, and we have to review this information. So it really does not negate our need to review. The review is not just for the order. So I just wanted to put that as well. The state has not received any deposit, and I did even offer to let the requesters request less and a lower number of jail calls so they could reduce the cost And they did have the dates of calls that they could request one call, but that has not been done.
Thank you, ma'am. Ms. Corey, let me just ask this. Does the state, not that this necessarily matters, but does the state intend to use any of these calls in their case in chief?
Judge, right now we have under consideration a few of the calls that we may use, and of course there are continuing calls, so we still have a few to look over. And I do have supplemental discovery for Mr. Strolla just with regard to things we gave him last week when we saw him down in Palm Beach. Yeah, last week. And so I do have to supplement the discovery, and one thing I'm going to make sure of is that there's an end to this number of calls. But quite frankly, Your Honor, we've used phone calls in our case in chief that came up after jury selection in other cases. So I can't make that commitment to the court. I can only say we are considering using some of them, which I would think would be make it somewhat obvious that some of these may have overtones of a confession, an admission, false exculpatory statements, for example. That's not something that the public generally understands is a confession under Florida law. But that would be another thing that we may need to use for if it were to become a false exculpatory confession. We are going to put Mr. Strolla on notice, and I think Mr. Guy already has sent him some of the ones that we may intend to use to try to help him streamline his trial preparation. But I truly can't answer that for the court right now. I can only tell you, again, that even if this case had zero publicity, even if there was no protection order, we would still be going through this. We do the same procedures day in and day out for public records, whether it's a closed investigation, a pending petty theft, or an important first-degree murder case. So we are going to continue to do that because we don't see anything in the district court's order that says you turn everything over to Mr. Gable that he wants. We simply aren't going to do that. That's not what the law requires of us.
One other question, do you ballpark, how many phone calls are we talking about? Just pure number, not time. I know it's 185 hours, which is a lot.
Judge, we can move on. I think my second supplemental discovery had gone through, I can't even remember. There's so many. There are just hundreds. There are hundreds.
Judge, it's several hundred phone calls, including hour and a half to 2 hour jail visitations that I have to go over as well. These are not just 15, 20-minute phone calls. There are several hundred of phone calls, including dozens of visitations, Your Honor.
And I detailed those in the discovery response, Your Honor, because we didn't realize that jail visitations come in on the same disc. So what we've given to Mr. Strolla are discs that correspond with time periods, and it says phone calls or jail visitations. So the phone calls are 15 minutes in duration if the person uses the entire amount of the jail call. Almost all of them are that length, and then there are just numerous. I mean, we think, yeah, and this isn't with the new discovery. There's 740 calls that we would have to sit down and listen to every word that's uttered to make sure that there isn't anything we're not supposed to be producing.
So out of 740 calls, you may consider using 6, 8, 10?
Maybe 10 at most, I would say, but still, there may be something even there we have to redact for the jury. You know, we may not even use all of the call. So assume that it were going to.
And of course, you might not use any because I might rule that none of them are coming into the trial.
And Judge, that's why I admit that's exactly right. That's the point. The reason that confessions and admissions are exempt, as far as I understand, is because if the state were to go out and talk about all this stuff and say, oh, we've got a really strong case against this particular defendant, not this, but I'm speaking rhetorically now, and talk about what we have, what's been furnished in discovery, and then there's a motion to suppress, and the court suppresses all the statements that have been publicized. Or assume the state attorney doesn't make any comment, but just turns it over to the media and they publicize it. You know, defendant so-and-so confesses to doing this, that, or the other. That's a headline that a jury may never hear. That's, again, why the rules of evidence are.
What, to be fair?
No, I don't think it's your job to show evidence that it wouldn't harm the defendant.
He's reversing the burden, right?
You got that right.
Thank you, Your Honor. But he has presented no evidence. He suggested something about judicial notice, but didn't say what you should take judicial notice of. Talking about his motion in paragraph 12, that the existing and future discovery materials sought to be protected are as follows. A, any and all jailhouse conversations of the defendant, including but not limited to any and all discussions, phone calls, and or visitations, but he cites no ground for why those should be excluded, no exception to the public records law. With regard to Ms. Corey's comments, she said it was ironic when she referred to the media, but it has occurred to me that it is ironic that the jailhouse letters that first brought all of this to your attention were released by the state attorney with no effort to try to keep those letters from coming out. And I don't know if anything was redacted from those letters, but at least the letters came out. As far as what was requested, I didn't quite understand what Ms. DeFranca was saying, but in the public records request on October 28, Mr. Hannon from the Florida Times-Union requested all discovery furnished by the state to the defendant to date in this case, and Heather Crawford from First Coast News said we would also like to review jail calls made to and from Michael Dunn and a list of the visitors he has had. So to say or suggest that they have to start from scratch through all of these calls is an artificial barrier. I have a copy of the transcript of the hearing on November 7, and page 22, Your Honor said, so you have gone through all 180 hours of these calls. Ms. DeFranca said, no, we haven't. Ms. Corey said, she hasn't, we have. Ms. DeFranca said, sorry. Ms. Corey said, you mean for public records? The court said, actually both. So you have for discovery purposes? Ms. Corey, yes, sir. The court, you've listened to them all? Ms. Corey, well. The court, your people? Ms. Corey, my intern has listened to all of them and given me a briefing on them. And the court said, a synopsis of what's on these calls? Ms. Corey said, yes, sir. So to say that they would have to start from scratch is creating an artificial barrier, really, to charge the full amount. They know what is in the calls. They may have to do some redactions. We understand that there has to be a reasonable charge made, but not for going from the beginning through all the calls.
I see. Oh, all right, thank you.
Thank you.
Thank you. Wait 1 second. Mr. Burke.
Briefly, Your Honor.
Sure.
Please, the court. Thank you, Judge Healy. Just wanted to respond to a few of the points made, both by Mr. Strolla and by Ms. Corey. Mr. Strolla, I think, suggested or at least implied that something untoward had been done by Channel 4 by publishing a copy of the motion to continue. If there was anything in the...
I didn't take it that way. The way I took it, maybe this will help, was that he was, and again, this is something that is new to me and completely, I'm sure, unknown to the public, is e-filing of documents, which the Supreme Court has mandated first in civil cases and now moving towards that in criminal cases. So, in essence, somebody like Mr. Strolla, who's in another town, can file a document with the clerk of the court here via what they call an e-portal. Not really sure about all that stuff, but he just hits a button and it sends it into space and it eventually winds up with our clerk. As I understand it, it then goes into a queue because hundreds and hundreds and sometimes thousands of documents are coming in by e-filing at a time. And so it goes into a queue, and the clerk takes them in order and starts pulling them out of this queue and actually filing the document with the court. So the document, while it got sent through this e-portal, is not truly filed with the court until the clerk pulls it out of the queue and puts it into the court file, if you will. And I know you know about these things, but just so you know, if anybody who's interested would know, what was unknown, I think, not only to the court and perhaps to some of the lawyers, in fact, from what I understand, it was unknown to some of the IT people that when an e-document is sent by, in this instance, Mr. Strolla, the e-portal has information about that case already. And it already has Mr. Burke's name, Ms. Corey's name, Ms. Wolfson's name, Mr. Gable's name, might even have my name. It may have a variety of names, other co-counsel of Mr. Gable and Mr. Burke. And now, as I understand it, that document immediately goes to those people. Even though it has not technically been filed with the court, it's now out there, and this is again ironic, because there's no telling what could be in it. It's now out there kind of in cyberspace, if you will, and it lands with whoever, quite frankly, some news media person's name might be in the e-portal, and maybe it would go straight to Channel 4 or to the newspaper. I don't know. So I don't think he was saying that there was something untoward about it. I'm gathering it was, just a bit of a surprise that the document was e-filed, and within 15 minutes, and this is just the nature of the way the world is going, within 15 minutes, not only was the document on the internet, but your people were pretty good, and they made a little story about it and put it on the internet. And it wasn't for several hours that the clerk actually, in this instance, pulled it out of the queue. Otherwise, it would have been even longer than that. And quote-unquote filed it. So it was truly a filed document. That's a glitch, I think, maybe in the system. I don't know. I don't know how that's supposed to work, but I think that's what he was referring to.
Well, Your Honor, I appreciate that review of it, and your impression.
Does it sound correct?
Well, I think it is, and your impression is what matters to us. There is part of that process, I don't know it precisely, but there is part of that process that guarantees or protects documents that contain confidential information or information that might be subject to redaction, not necessarily information that is subject to an order, but just might be subject to an order. It's the filer's duty under Rule 2.420, as you know, and under 119, to bring to the clerk's attention using a form. There are 19 statutory or enumerated categories of documents that are exempt, or just a generalized motion to determine confidentiality of records that should accompany or be the cover sheet on the document that the filer wants to have reviewed. So there was nothing about that motion that indicated there was confidential information in it. And frankly, Your Honor, I think you do accurately describe the process, at least as far as I understand it. But it's no different from the email service that we've had a year or so, maybe a year and a half, that the Supreme Court instituted. And so you're right, the e-portal is an automatic thing that takes care of this very quickly. But in terms of the effect is that I could upload a document to be filed or send it, put it in the outbox to go have the runner take it over, and then serve it by email, and all the parties would have it before it ever reached the courthouse.
So I guess, and this is really kind of off the subject, but what I'm hearing you say is that if the sender, no matter who it is, either clicks the right box or has some cover sheet that says, I'm hoping that the clerk and or the court is going to look at this and determine whether or not some of this is confidential, it still goes out to quote-unquote other lawyers or parties, it's kind of on the, well, as officers of the court, then you would not disseminate those types of things. I don't know if it goes to civilian parties or not, who are not subject to our rules. But it's kind of, I guess, the honor system at that point that something doesn't then get disseminated if there is a caveat that's obvious that it should not be until a ruling is made.
I think that's right, Your Honor. I don't know, technically speaking, if, and there is a place on the e-portal to designate if the document being filed contains or should be subject to confidentiality review. There is a place to check a box and to say. I don't know if upon doing that, the document would be served right away by email as the non, I don't know. But you're right, if a document said, you know, motion to determine confidentiality and contained information, it shouldn't be disseminated until heard by the court. It's a little bit hard to, well, I want to make sure Your Honor understands, and I won't speak for my colleagues at the other media, but I think they're on the same page as we are. We're not asking for documents just to be handed out willy-nilly, tape recordings. They have to be reviewed or redacted. You know, the one way to read the DCA's order, I think, is that they should be released. But, you know, we understand, and the state attorney has very nicely confirmed my point for me, that whether there was a public records request or not, she would be reviewing these tapes for, you know, the specific exemption for substantive confession, or there are 4 categories of information that all filers have to be wary of: Social Security numbers, bank accounts, birth dates, I think, and there's a 4th category. And it's the state's obligation, the custodian's obligation, to review those documents so that that information doesn't make it into the public record accidentally. Moreover, Chapter 119 in the case law construing it says that an agency, a custodian, certainly can recover actual costs of complying with a public records request, but the custodian cannot recoup the cost of doing business through charging for a public records request. So in this case, we would say, Your Honor, that if the state attorney has already gone through, for evidentiary purposes, substance of confession review, has already gone through for those other enumerated information, Social Security numbers, et cetera, that should not become public without a specific reason. If they've already done that as part of their duties as the state attorney, they cannot now come back and charge the requester to recover or recoup their cost of doing business. All they can recover is the actual cost. And I'd be glad to provide case laws that I can will support that point, Your Honor. So we would say if the state has done that, they really can't charge us for it. Only to the extent that they do something that wouldn't have been required for their custodian duties and evidentiary purposes.
I see Ms. Corey. I'm sorry, Mr. Brick.
That's okay, Judge. I know Your Honor knows that admissibility is not the standard.
No, it's not. It's, again, and that's one of the, it's not irony, that's one of the conflicts that, you know, some folks would say that what should be out there would be only things that would be admissible in a trial. Others would say, no, it can be more than that. And quite frankly, clearly, the state of where we are now is it's more than that. It's not just what comes in a trial. But that's just where the law is.
Thank you, Your Honor. Thank you,
I'm sorry,
Judge.
Mayor, again, I have to clarify 2 things. I didn't review these tapes or have my paralegal review these tapes for public records purposes. I'm trying to get ready for a criminal trial. And I'm doing that the way I've done it for 32 years. It's my obligation to look at everything, to figure out what we're going to present our case in chief, to figure out what we may need for rebuttal if the defendant takes a stand, if he doesn't take the stand, if anything else comes up. And the other thing, so these have not been reviewed for public records purposes. I would be the person sitting and doing that. I'm sure there'd be some headline story that I spend all my time listening to jail calls. But beside that, Mr. Gable just mentioned, why would the state attorney release these? The media starts their stories off a lot of times with the state attorney's office released documents. And I believe, and correct me if I'm wrong, Your Honor, but I think even one of the district court panel asked, why would the state attorney release these? First of all, we don't release them like a media release. We don't do that. We comply with Florida's public records law. And so to clarify the confusion about what somebody can access on e-filing, the reason that there was an issue with admissions in a different case is it was contained in an arrest docket that got posted unredacted, because the clerk does have that entire document. But for purposes of the Dunn case, the clerk gets a copy of our discovery response, which gives an inventory of what we've turned over to the defense. So the clerk doesn't have copies of the phone calls, copies of the letters, or anything else that the media may wish to request through a public records request. So they're left with requesting that information, the specifics, the actual calls themselves, the actual body of the letters themselves from the state attorney's office. Once I furnish it in discovery, it becomes a public record subject to redaction. And that's what we've done. We've complied with our public records law. We're not releasing this so that the media can publish it to someone. We would have never turned over those letters had there not been a specific request for them. So we are caught in the middle where, had there been something in those letters, we would seek protective order. We would have come into you with copies of the letters as evidence saying, we think you need to protect this. I understand we're now in a position where we have to come to you and present evidence. And again, I'm going by what we've discussed based on what the DCA has asked you to do. And Mr. Stroll has got to present evidence, and we have to present evidence with regard to the phone calls. The reason we haven't done that yet is because no one has said they are willing to pay for the phone calls. So I'm not sure what we're supposed to be doing here, Judge. I really am not sure. The motions have gone round and round. The issues are overlapping. We believe those phone calls should not be released. We think those are subject to the high standard where the defendant's right to a fair trial supersedes the media's right to know. We think we can establish that standard. We know the DCA has asked you to have us establish that standard. But again, if the media is not going to pay the deposit and have us begin that work, then there's no reason for us to do that. So it's a little bit confusing still. But I am representing to you as an officer of the court that we believe that the phone calls specifically should be protected with regard to this case. So now that puts us again back in the position of having to have you review something that might not get released because they're not following proper public records. But I'm telling you as an officer of the court, I have not reviewed those calls for public records purposes. That's why Mr. Franz is our public records attorney, because she knows all the exemptions and they have to review it and get it ready for response. It's not a release, it's a response pursuant to 119.
Judge, and if I could just briefly respond for Mr. Dunn.
Okay.
And very brief, Judge. Mr. Gable brought up my motion and cited paragraph 12 from that portal, Judge, from January 17th, 2014, with my motion to continue, shows I'm the filer, and the electronic notice was only sent to number 1 is myself, Corey Strolla. Number 2 is George D. Gable Jr. from Holland and Knight Law. Timothy J. Connor from Holland and Knight Law. Michael Groper from Holland and Knight Law. Aaron Wolfson, who is a state attorney. Again, myself at an alternate address. Mr. John Guy, who is at the state attorney's office. And Crystal, I think it's Broughan, B-R-O-U-G-H-A-N, who is an attorney, or somebody at marksgray.com, Judge. No other email service was given to anybody in the media or a civilian. It was all interested parties, being attorneys, who get certificate of service with that motion that I filed. And again, my point was, if we turn over these tapes without a protective order, Judge, or phone calls or visitations, I'm still drafting motions to keep what I think the state may use in limine out, Judge, and let alone if I file a motion in limine and all these statements are out days before trial, which you may keep out, Your Honor, or the state may very well not even use, it's going to deny justice to my client. And it goes back to, and I apologize, I gave you the wrong site, Judge. It's the Florida Freedom Newspapers versus McCrary, which was 520 Southern 2nd 32, which is the Florida Supreme Court, 1988, who cited Estes, E-S-T-E-S v. Texas, 381 U.S. 532, the U.S. Supreme Court in 1965, that quotes, the United States Supreme Court has characterized the right to a fair trial as the most fundamental of all freedoms and one which must be preserved at all costs. And again, not one single person from the petitioner has presented any evidence or argument why the right to the public to have the media get these records and disperse them supersedes my client's most fundamental freedom of a fair trial, Your Honor. And that's what we'll stand on.
All right. Last time, Mr. Gable.
Your Honor, my response to that is it's only argument of counsel. It's not evidence, and it's his burden. And the other is to repeat the page 22 of the November 7th hearing when you asked Ms. Corey, have you all gone through all 180 hours of these calls? Ms. Corey said, you mean for public records? And the court said, actually both. So you have for discovery purposes. Ms. Corey said, yes, sir.
Yeah, and since I was there, let me tell you how I came away from that. And I see the problem still seemingly exists. What I understood was that Ms. Corey, and not Ms. Corey individually, but her lawyers, reviewed these calls with an eye towards whether or not they could use any of it in their case in chief or in rebuttal or something like that. What I further gathered was that when a public records request is made, Ms. Corey had other people, public records people, Mr. Franza or people at her direction, review these documents with a different eye towards what they're looking for or looking at. I can see where somebody would review these looking for some statement by Mr. Dunn or some potential admission or something like that, never listening for a Social Security number, a bank account number, or some of these other things that are statutorily excluded. Now, should they make a note of that or something? I don't know. I don't know how they do their business. As I understood it, once a public records request comes in, the state attorney sends it over to another department, if you will. They start looking at it with their eye towards the enumerated exclusions under the public records law, and then they do whatever they do, redact or whatever, and that's when they then comply with the public records request, which also requires some monetary exchange depending on, I guess, the amount of work or reproduction that needs to be done. That's all kind of beyond me. I understand that's the way I understood it. So it was like two tracks, and they had reviewed these things on one track but not the other, and that's what I think Ms. Corey is still saying. They've reviewed it for one track, and they still haven't reviewed it for the other, which is a bit problematic because, and this goes back to my order to begin with, I tried to put a buffer in there so anybody, whether it was the state attorney's office or the defense, quite frankly it could have been the court, could review these things because of the volume of it. 180 hours of phone calls is 180 hours of phone calls. It's going to take you at least 180 hours to listen to it. And so that's why I tried to put a buffer in there, which didn't work. But it just points out, you know, in our new age of electronics and things of that nature, how difficult it can be to comply with everything you have to comply with. Let me go back a minute. Mr. Strolla made mention because I've separated these things into two issues. One is about and I hear you, Mr. Gable, they do kind of dovetail a little bit from your point of view. The state's kind of saying, no, I'm in between. It does a little bit. There's the witness issue, the confidentiality of witnesses, which is issue one. And then, in my mind, there's the jail call issue. And some of these clerk's entries and the redaction there will clear up depending on what the ruling is on those issues, particularly the witness issue. Mr. Strolla mentioned that, and he's correct, there was an April order that everybody knew about that wasn't appealed and wasn't objected to. There was an August order that extended these things that everybody realized and knew at some point whether they had time to file a motion for rehearing or an appeal. It was clear because the media covered it, while there might not have been a specific notice, but the media covered it. And so I hear the argument, well, then that means there's nothing you can do about it. But that's not correct, because the rule of judicial administration, Rule 2.420, E5, allows for a non-party to request that the court vacate all or any part of any order that was issued pursuant to that rule. So we're properly here on that motion. The media can file the motion based on that section of the rule and ask that those things be vacated and set aside, which would then cause the disclosure of the witnesses' names and addresses. The district court, the way I read what they've said is that I had to have an evidentiary hearing to determine whether or not these witnesses' names should continue to be held confidential. I believe they also required that I have an evidentiary hearing regarding the jail calls. And so far, I haven't heard any evidence. I've heard a lot of argument, but I haven't heard any evidence. The interesting thing is, and I've done a lot of research, or had law clerks do a lot of research, and myself as well. And I just say this, I guess a little bit for the record. One of the issues about the witnesses, and the case law seems to indicate, that I've read, that there are certain things that would have to be alleged and ultimately shown to keep a witness's name confidential. One problem so far is we haven't had any evidence to that effect. But the cases also go forward and talk about, obviously, the media's right to know, but they also talk about the witness's right to privacy and whether or not the witness would want their name and address published or out there in the public domain. And the cases, oddly enough, talk about the fact that the burden is actually on the witness to come forward to present something to the court to say, here's why I don't want my name and address out there. Obviously, that hasn't happened. And in fact, there's one case, and I believe it's Times Publishing Company versus the state of Florida and Joseph Smith, if I'm not mistaken. That's 903 Southern 2nd 322, where the court talks at length about this problem and how would a witness know to ever come forward to say, I don't want my name and address out there. How would they ever be put on notice that their name and address could be placed out there? And then the court goes on to say, in that case, because nobody came forward, they don't reach the issue as to whether or not the state, and that's what they say there, and in my mind it would also include the defense, would even have standing to bring that issue up before the court on behalf of the witness. And it would seem to me that you probably should, but I haven't found a case that says the state has standing to bring that issue before the court on behalf of the witness. I haven't found a case that says the defense has standing to bring that issue before the court. I say that because maybe if somebody reviews all this, it's something that ought to be cleared up as to who has standing to bring that issue. The ironic thing about the jail phone calls, to me, is, and again, another very interesting case, it's a 4th District Court of Appeal case, Bent versus the state of Florida, 46 Southern 3rd at 1047. Very similar to this case, the media in that case, there, though, asked the sheriff's office, pursuant to a public records request, for the jail phone calls. The court went on to have quite a discussion about whether or not jail phone calls are even a public record. In that opinion, they found that jail phone calls are not a public record. They go on to have a further discussion about the fact that public records laws deal with the ability of the public to watch what government's doing and see what the government's about. There they talk about the jail phone calls and the purpose of recording inmates' phone calls. And the purpose, from law enforcement point of view, is to determine whether or not there's any ongoing criminal activity and whether or not there's a safety issue, an attempt at an escape or something like that. And they say, so if those issues are found, that would be something that could be a public record. If they're not, they find that those calls are not even public record. They further go on to discuss, again, the third party, the other person on the end of the phone call. They discuss the fact that all the jails, when a call is made, there's something at the beginning of the phone call that says, your phone call is being recorded. The defendant knows it, and the person on the other end of the call knows it. But what that case discusses is that while the person knows the call is being recorded, they do not know, and they're never placed on notice, that their call could be made public and could be disseminated to the public. And they talk about their due process rights to protect their own privacy and things of that nature. Fascinating case. But the problem that I see comes in when, and it's just an odd thing, because in that case you can't tell, and it was a murder case, you cannot tell whether or not those calls have been listed in discovery by the state. I don't know whether it had or hadn't. Maybe it hadn't, because that's why the media asked the sheriff's office for the calls, as opposed to asking the state attorney's office. So then you get to the interesting thing. What is not a public record, clearly based on that case, how does it become a public record, or can it become a public record? Even though they talk about the purpose of the public records, and the purpose of the public records law does not include this type of phone call, this type of government activity, if you will. What I guess is when the state decides to listen to the phone call, whether they're going to use it or not, and let's just pretend they're not going to use it, it had no value whatsoever, they're required, under our rules of discovery, to let the defense know that they did it. So they list that on discovery, and seemingly then what is not a public record and cannot be considered a public record all of a sudden now becomes a public record and is subject to disclosure. You still have the same problem, though, that they discuss in this case, and that is once it gets ready to go out to the public, the third party, if you will, has rights and could come in before the court to try and present evidence as to why their call or their end of the call should not be made public. Again, we don't have any of that here, but it begs the question again, how would the person know? How would some individual who was on the phone know, I better run down to court on my own, I guess, and file some sort of a motion with the court to say, I don't want my phone call out in the public. I just say all that because it's a very, very interesting and somewhat troubling position that some people could find themselves in. Where that'll get, how that will get solved or resolved, I don't know. I really don't. But let me back up and say that because I believe that we were required to have an evidentiary hearing today and none has really been presented, I'm left with the task of obviously getting a written order out, which I'll do as quickly as I can.
Well, Judge, I'm sorry, if I may, and I don't want to speak for Mr. Strollo, the problem with having an evidentiary hearing is if we reveal the content of the phone calls, we're in a public forum, and then it gets, blasted to the public anyway. I believe that the state and the defense are between the proverbial rock and hard place. I believe that it's Florida's broad discovery laws that are creating the perfect storm. Florida's broad public records law, and I am seeking to get a lot of this clarified. I'm hoping our legislature will listen to us on these issues. And again, we're not saying it should never be public. We're saying it should be public after there's been a fair trial. And that's all we're saying. But we can present evidence to the court, but we don't want to do it with cameras rolling.
Well, and Mr. Burke's on his feet, but I'm probably going to say what he was going to say. And that is there's a provision in the rules for that. There's a provision in the rules of judicial administration, and I believe a provision in the rules of discovery that if there's going to be an evidentiary hearing about this type of matter, a party can ask that the hearing be, quote-unquote, closed. And by that I mean no media coverage of it, so that the specifics of the request can be made. For instance, a witness could come in and say, my name is so-and-so and my address is such-and-so, and here's why I don't want my name and address out there. And that wouldn't be covered because the court might say that's going to be confidential. And so it shouldn't be out there. So you're 100% right. You can't have an open hearing when you're discussing matters.
Either an affidavit or,
Well, the problem that we're facing right now, Mr. Burke, is she's not going to be in a position to do that, because if I grant your request, these folks' names and addresses are going to be out there within a couple of days. And it is what it is.
Sure.
Now, is anything going to happen? And that's the other hard part about it. Quite frankly, I'm not sure how anybody could come forth and necessarily meet their burden to say, I don't want my name out there. You have to talk about, harassment or intimidation or things of that nature. And I'm not sure you would ever know that that was going to happen until after it happened. And then, by that time, the person's name and address is already out there, so it's just this revolving catch-22 that, again, it's something that ought to get, and I don't know how you fix it, but it ought to get clarified, or there ought to be some provision in there to and again, 99.99% of the cases, this just isn't an issue. Nobody ever looks in this deep to it. Nobody cares who the witnesses are. Generally speaking, if there's going to be harassment, it's from parties within the case, not from the media. In this instance, somebody might say, well, I just don't want the media at my front door this coming Saturday trying to interview me. because my name was listed and I'm going to be a witness in this case. But I don't know, I just don't know how to, I don't know how to fix that. So I hear what you're saying.
Thank you, Judge. A closing point, if I might, is just on the two converging paths of evidentiary review and public records review. We believe in this instance, with regard to the tapes, they have converged and are one and the same. And the answer to that, not to give you extra work, but is to review in camera the summaries that I think the state may have already provided to you, and determine whether there's been review that, you know, for both public records purposes and for evidentiary purposes that would also satisfy the public records purposes.
Well, let me address that, and then we're going to conclude with one portion of this resolved. Yes, the state has summaries that they provided to me with the idea that that would give me an idea of what was in these phone calls. I did review much of that, and it's voluminous. Just that. Forget listening to the phone calls. But it is clearly somebody's view of what was said, and there are a synopsis, if you will, of the call, some of which is very general. It doesn't describe in detail the call. It does point out things, and this, I hate to say it, kind of makes Ms. Corey's point. It does point out things that I can see whoever's listening to this is trying to convey to the lawyer. Ooh, this might be something you might want to try and think about using in the trial. From what I saw in what I read, I never saw a bank account number. I never saw a Social Security number. I never saw any of that. Whether it's in there or not, I have no clue. The only way I'd ever know is if I listened to the calls myself, which I have not done. So I hear again what you're saying, and I'll say this. I do believe those things are the state's work product. In fact, they discussed that, and I said to them, I kind of encouraged them to let me consider looking at it when I was trying to put this 30-day buffer into place. And Mr. Strolla even conceded that it was their work product and that he wouldn't ever ask to see it if I saw it, but that it was a way for me to be able to look at these things and maybe get a quicker idea of what we were dealing with rather than having to start listening to 180 hours of phone calls, which again, you know, is for some higher court to consider. I don't know how a judge would ever sit down and start listening to 180 hours of phone calls. That would take, at a 40-hour week, that would take 4.5 weeks to do. So there goes a month, a little over a month to do that all by itself. And you think about some of these high-profile cases nowadays, there's volumes and volumes and volumes of things. You'd have to take the judge off every other case they had and dedicate them to one case, and you'd still be going on forever before you got to a trial. I had 100 cases on my morning calendar this morning because I had 50 felonies and 50 misdemeanors, which is another part of the reason I had to back this up. Justice can't work that way. We can't assign one judge to handle a case like this to the exclusion of all other work. So I just say all that because it just points out the difficulty of it all. So, you know, I do want to say that that summary, and I hear Mr. Gable kind of conceded that it was work product. Your client wants to take a different view, so you've diverged there.
We haven't seen it, so we don't know.
Yeah, well, it is.
I would respectfully submit, Your Honor, that if there are portions of those summaries that indicate that some of the recordings do not have any substances of confession or other material that would be exempt, then those summaries themselves will tell the
such non-disclosure only if ordered following a full evidentiary hearing and a written order based on factual findings and appropriate legal analysis based on evidence submitted during the evidentiary hearing. Thank you, Your Honor.
It also goes on to say they have to pay for it and go through the normal.
It does. And again, interestingly, it says, to boil this down, to make it as simple as possible, it says these things need to be disclosed unless there's an evidentiary hearing where the court can make findings to say otherwise. And it goes on to say, subject to the state's responsibilities under the public records law. And in fact, there's yet another case that I read that was, if I can put my fingers on it, about that give me a second. Basically, it was a case, and I don't know if I've got the cite to it. Yeah, I've got it. This is 5th District Court of Appeal case, Ingram versus State. I've only got the Florida Law Weekly cite, 213 WL 6687815. Anyway, a defendant there asked for some public records or some records to be provided pursuant to public records law. The state took the position that it required almost an expert to do some redacting as it related to the identity of a victim in a sexual battery case. And the court there said, no, the custodian of the records, which in this case is the state, has the burden of complying with Section 119 and doing the redaction. So from what I read, that's their burden and that's what they need to do. So let me back up. I'll get a written order out as to these things as quickly as possible. As to the motion for continuance, Mr. Strolla, I recognize that this media business has been a bit of a distraction and that has caused you to spend some time diverted from focus on trial preparation and focused on this. This will be resolved today. There will be no further need, I don't believe, for you to focus on this type of thing other than as it would relate to the trial, which you would be doing anyway. And the amount of time that has been spent on this thus far, from what I can review based on the pleadings and things of that nature that have been filed, is not something that would rise to the level that would warrant me continuing this case. This case will proceed to trial on February the 3rd, and I'll get a written order out to everybody else about the remaining issues. Thank you all very much.
Thank you.
Circuit Court Division CRD. Recess.
Ready.
As soon as everybody's out, let's all get together in the jury room.
We got two, so.
You too, Woody.
Woody's probably got it.
You know, I've listened to some really argument about 3 or 4 different people, and the same attorney, same arguments. They just need to, I guess, get like a consensus. Ma'am?